Major news today in the Second Amendment, a hour-long oral argument in the Fourth Circuit Court of Appeals in Richmond, Virginia, over whether or not Maryland's so-called assault weapon ban, which yes does exist, is constitutional. Stay tuned. We'll talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms. Today, Bianchi versus Frosch, major argument. This is a case that had been decided before by the Fourth Circuit Court of Appeals based in Virginia that said that Maryland's so-called assault weapon ban of AR-15 style firearms and AK-47 style firearms were constitutional under the Second Amendment, but the panel decision did so based upon prior Court of Appeals precedent from the Fourth Circuit, a case called Kobe, which said that semi-automatic rifles were bannable. You could ban them under the Second Amendment because semi-automatic rifles like AR-15s were like M16s. Terrible logic, but that's what the Kobe court said. Many years ago, because M16s and the like are not protected by the Second Amendment. They said that AR-15s and AK-47 semi-automatic rifles were like M16s, therefore are not protected arms under the Second Amendment, which I think is clearly wrong. But that's what this case today, Bianchi versus Frosch, was all about, because the Maryland so-called assault weapon ban remains in place today. So what happened today? Very interesting. To begin with, we had a 3-judge panel. I predicted the panel before. Now it turns out this morning they switched out one of the judges, but not in a way that I think is necessarily bad for us, although there was an excellent judge that was originally on the panel, but he got removed this morning, perhaps because he had taken senior status or something like that. But the bottom line is the 3-judge panel of Niemeyer, Thacker, and Richardson heard the case. The one judge we can totally write off as someone that will never rule in favor of the Second Amendment is Stephanie Thacker, a judge appointed to the federal bench by Barack Obama. She was clearly hostile to the Second Amendment today. In fact, she even thought the Kobe case was still good law, despite the fact it was clearly overturned or thrown out into the garbage pail of history by NYSERPA versus Bruin. But she still thought it was good law, and that's what she tried to make the case of. And she opened up by talking about AR-15s and shooting up Walmarts, which, of course, has nothing to do with the Second Amendment, as we know from the Supreme Court's multiple precedents to say that any kind of public policy interest balancing test is not appropriate for the courts to be doing when we have a Second Amendment, which was in and of itself a product of interest balancing. But we have 2 judges. One, I thought Julius Richardson, who was appointed to the federal bench by President Trump. I thought he did a good job. And I think that also Judge Niemeyer is going to rule in the favor of the Second Amendment and against this assault weapon ban, because he had done so in the Kobe case several years ago. He was dissenting in the Kobe case. I think the good news is we're probably going to win this case 2-1 in favor of the Second Amendment. The Maryland so-called assault weapon ban should be struck down as unconstitutional. As to what happens with the case after that, does it get en banc? Does it go to the Supreme Court? We won't know until that happens. But for the moment, I suspect it'll be a 2-1 decision in favor of the Second Amendment. But I do want to give you, there's some really important arguments that were raised by the anti-gunners today that at the end of the day, I think are meritless. But we need to pay attention to these arguments, because this is the kind of argument we're going to see not just in any kind of argument about whether or not people can ban, governments can ban AR-15s or AK-47 style semi-automatic rifles, but also involving standard capacity magazines, which the anti-gunners like to label with propaganda terms such as high capacity magazines or large capacity magazines, which of course are propaganda terms. But we'll talk about magazines another day. For now, we're just going to talk about this argument in Bianchi versus Frosch. So bottom line is this. The legal standard here and the courts were, the one thing that bothered me about today's argument is I felt that the judges were not quite up to snuff, not quite keen on how the methodology of NYSERPA versus Bruin worked in light of the Catano and the Heller decisions. I'm a little sympathetic to all judges. Keep in mind that judges have dozens and dozens and dozens, if not hundreds of cases they have to deal with every year on all kinds of subject matters. It's not like someone like me where I can spend, the bulk of my time on my YouTube channel, for example, talking about the Second Amendment, and I can think about all the ins and the outs of it. But most judges, they have criminal cases, they have Second Amendment cases, they have First Amendment cases, they have Fifth Amendment cases, they have, ERISA cases, they have contract cases. So they have all these cases on all these topics. So it's very difficult for them to become subject matter experts in any one case, which is why it's so important for the judges to be able to rely on the lawyers to give them the critical facts and the law and the analysis, because these judges are overworked. And therefore, they can only spend so much time learning about the history of the Second Amendment because they have like dozens and dozens, if not hundreds of other cases they have to deal with. So that's a little bit of a limitation that lawyers who argue in favor of the Second Amendment have to deal with. It's part of it is the education process of getting judges up to speed about how it's done. And I thought that the three-judge panel was not quite perfect in terms of how they were thinking about this case. They weren't terrible, but I think they were a little off in terms of based on their questioning. We'll see what the final decision, it may be perfectly fine and nailed, but a lot of their questions, I think, you could see they were struggling to try to understand the methodology of Heller and Bruen. So we'll talk about how that's done in the future, but it's really quite simple. As you know, you have the Second Amendment. It has text, and the text protects the right of the people to keep and bear arms. The text is not to be interpreted in a naked vacuum, right? In a vacuum, it is to be interpreted as explained and defined and interpreted by the U.S. Supreme Court. The U.S. Supreme Court has defined all the key terms of the Second Amendment. It defined well-regulated militia. It defined the people, which is all Americans. It defines arms as, all things that can be used offensively and defensively. It talks about the word keep, which means to possess, to own. It talks about the right to bear, which means to carry in public for self-defense. All these things have been defined by the U.S. Supreme Court. So when you're dealing with a ban on a firearm, such as AR-15s or AK-47 semi-automatic rifles, you are clearly dealing with banning guns that are arms, and you're limiting the ability of people to keep and bear these kinds of arms. And the good news is the Supreme Court has already laid out the test for this. And I'll tell you why this is so important. And I think the judges got a little confused by this, but hopefully it'll come around and be clear when they write their long opinion. You see, in the Heller case in 2008, the Supreme Court looked at the history associated with the Second Amendment, and they said that when a government agency tries to ban a type of firearm, a type of arm, not just firearms, but a type of arm like handguns, then they are not allowed to do it unless the government can demonstrate that those firearms, those arms, are what are known as dangerous and unusual. Dangerous and unusual. And the Supreme Court went on to say that that's the government's burden to show that a gun that they're banning is dangerous and unusual, which is language they got from William Blackstone's commentaries from England. But for your pro-Second Amendment people out there, don't worry about that standard. That standard is not bad for us, and here's why. The government has to show that a gun is dangerous and unusual. Now, what exactly, by definition, is something that's not dangerous and unusual? Well, something that's commonly possessed and commonly used by Americans for lawful purposes. So that means in Heller, they said that handguns, whether it be revolvers or semi-automatic handguns, were commonly possessed by Americans for lawful purposes. Therefore, they could not possibly meet the definition of dangerous and unusual. So therefore, they're protected. So in Caetano, the Supreme Court pointed out that 200,000 stun guns owned by Americans were commonly possessed. We know, of course, that now we know that handguns are protected arms because they're commonly possessed for lawful purposes. We know that stun guns are protected arms because they're commonly used for lawful purposes. Now the question is semi-automatic rifles. Now Judge Kavanaugh in the Heller 2 case, when he was on the Court of Appeals, dissented in a decision where he concluded that, of course, semi-automatic rifles are clearly commonly used or commonly possessed by Americans for lawful purposes, so they're protected. Well, that's what this case of Bianchi versus Frosch and these so-called assault weapon cases going on around the country are all about. But again, we know, and here's the key, the Supreme Court did the test. They looked at the history and they said that if a ban of a weapon, of a ban of an arm, is a ban of an arm that's commonly possessed, it's unconstitutional on the Second Amendment, game over. Now, this is a critically point. I've talked about this before. I'm going to keep talking about this more because I realize it's getting confusing to people. Okay, you ready for this? Bruen talks about a burden thing that says that once the plaintiffs who sue on behalf of the Second Amendment demonstrate that a law or regulation touches fingers with or implicates the right of the people to keep and bear arms, then the burden goes to the government to demonstrate there's historical analogs. In my view, in the founding era, 1791, there's historical analog gun control laws that are analogous to the modern day gun control law to justify it. They have to prove that. Now, here's the thing. Today, the judges were a little confused about the common use test. They were thinking that the common use test is kind of part of their, it wasn't quite clear how they were trying to get to this, but they're trying to say, well, common use test tells us what kind of arms are protected. And then once we are talking about arms that are protected by the Second Amendment, the burden shifts to the government to show historical analogs. But this is absolutely wrong. This is absolutely 100% completely wrong methodological under Bruen and Heller. This is what the anti-gunners would try to argue because they want to win at all costs. I don't blame them. That's their job. But the reality is clearly wrong. And here's why. You see, in Heller, the Supreme Court did all the historical work for all of us, including the Fourth Circuit Court of Appeals and Bianchi. The Supreme Court says, we're going to look at all the history involving gun bans. And they did that. And they said, we've looked at all the history. We looked at the United States versus Miller case in the 1930s. We looked at Blackstone. They looked at all this precedent, all this history. And they said, look, we've concluded that the only types of arms that can be banned from being owned in the United States are those that are dangerous and unusual. But if they're commonly possessed by Americans, they cannot be dangerous and unusual. In the context of Heller, they talked about handguns being not commonly possessed, therefore they can be dangerous and unusual. So today, where we have between 20 and 40 million people owning, or 20 and 40 million, semi-automatic rifles in the United States, if not more, that is clearly commonly used. So therefore, it is game over. There is no shift to the government to try to show historical analogs because the U.S. Supreme Court had already did all of that work. They looked at the historical precedents. They looked at the historical analogs. They already did the history. And they said, based on all the history we've done, the relevant test is dangerous and unusual. And conversely, if a weapon is commonly possessed, it is a protected arm. And the reason why they said that is because in the time of the founding, when people were called out to muster for militia duty, what arms did people bring with them to militia duty? They brought the arms they had in their homes, in their farms, in their apartments, whatever it was. People had arms at home, and when they were called up to go to militia duty, they would bring the guns and the weapons that they had in home, in their farms, whatever, and bring it to militia duty. That's what the U.S. Supreme Court said. They already looked at the historical analog laws, including the Militia Act of 1792, to sort of prove the point. So the anti-gunners try to argue that the burden is on the pro-gun plaintiffs to argue and to demonstrate that AR-15 style firearms, that these semi-automatic weapons, these semi-automatic rifles, are commonly used by Americans for self-defense. And therefore, they basically say that you have to show that people are actually using these guns for self-defense. But that's not technically the standard. First of all, the Heller court in the United States, and the Supreme Court said in Heller that arms in common use for lawful purposes like self-defense. Let me read that quote from Heller back to you. Okay, commonly used for self-defense, okay, is not commonly used for self-defense. It's actually commonly used for any lawful purposes. That's what the Supreme Court said. Any lawful purpose, not just common use. And one of the judges today, I think it was Judge Richardson, talked about, well, can't people, use guns to prepare to thwart tyranny? Can't they use guns for recreational purpose? That's a lawful purpose too. It's not just self-defense. So there seems to be pushback on the government's position, but the Maryland government was arguing that really that it's only commonly used for self-defense weapons, and because AR-15s are rarely used for self-defense, therefore they're not protected. But that's wrong for, again, two reasons. One is that the Heller specifically says that guns are protected if they're, quote, if they're in common use for lawful purposes like self-defense, not exclusive of self-defense, but like self-defense as one of a series of examples of lawful purposes. We know there's many other lawful purposes like hunting and the like. Okay, so that's the key point. Beyond that, we also know that they tried to play this game between possessing arms and using arms. So what they were trying to say is that the pro-gun plaintiffs have to prove that people actually use these AR-15s for self-defense by shooting them. And because there's not a lot of examples of people using AR-15 shooting these things for self-defense, therefore you can't prove it. But of course, we know that's not true. And I thought the lawyers did a good job for our Second Amendment team by pointing out that basically, holding a gun, police officers carrying guns, having a gun in your home, you are effectively using that for self-defense. Like when I go to bed at night and I have guns around me, well, I'm using the guns even if I never pull the trigger. Police use the guns just by possessing the guns in their holster. They may never take it out of the holster, but they're still using the guns. So I think the court was pretty savvy on this. But the anti-gunners are trying to narrow the scope and the test from firearms are protected if they're used by Americans for lawful purposes. They're trying to shrink it down to say that they're only protected if they're used by Americans for self-defense purposes, and they have to go out and demonstrate that they're actually used physically for self-defense. And the reality is they never are. At least or they're rarely used. And what they're trying to say is even if they are used for self-defense, they're not commonly used for self-defense. So this is mission critical that you understand this. The anti-gunners are trying to say that guns are only protected under the Second Amendment if they're commonly used for self-defense. Used meaning you actually shoot them. That's how narrow they want to be. But of course, we know that the Second Amendment is a doomsday provision, and the fact that you may have to fight off a tyrannical government or insurrection, or you may have to fight off an animal attack or a criminal attack, all these things are by definition rare events. So by definition, and this is why the anti-gunners are trying to narrow the scope of commonly used to go away from we happen to own guns in case we need them for the purpose of confrontation, to trying to argue what they're saying is you have to demonstrate that people commonly use guns to shoot people in self-defense, which of course is a rare event. But the whole Second Amendment is about rare events, right? Because most people are not using guns every single day to shoot people. That's just not how it works. So by definition, of course, it's rare. But again, that's not what the Supreme Court said anyway in Heller. It's just you have to own them you have to commonly own them for lawful purposes, including self-defense. But that doesn't mean you have to shoot it for self-defense. You can just have it for self-defense. But again, the anti-gunners are trying to get around that. The other interesting thing that the anti-gunners were arguing is they actually made the case that to show these firearms are common use, you have to break it down. So they were trying to make the case that AR platform firearms should be looked at separately from AK-47 semi-automatic arms. They say that you got to break each of these down, but that's clearly not true because, for example, in Heller, they took the entire category of handguns and said they're protected. In Caetano, they took the entire category of stun guns and said they're protected. And here, of course, we're talking about the entire category of semi-automatic long guns or semi-automatic rifles are protected. You don't have to show that, one brand of gun, like a Glock, is commonly owned versus another brand of gun, like a Ruger or whatever it is. You don't have to break it down to make and model. You just have to show that the classification, the type of gun, in this case, semi-automatic rifles, are commonly possessed. And we know, of course, they are, to the tune of 20 to 40 million of them. Who knows if not more. But of course, that's what the anti-gunners are trying to do. So, okay, hope you learned a little bit something. The bottom line is I think the Second Amendment is going to win 2-1. The methodology and opinion that they write will be very interesting. I hope they get it right. There are some questions that suggest they were a little bit confused about how to apply it, but that's not unusual in oral argument. That's why hopefully oral argument helped clear things up for the court, and they can reflect on the briefs and whatnot, which is, again, the judging process. Okay, hope you learned something here today. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.